Welcome. I was actually just thinking about, while people were coming in here, about the first time I spoke at RSA. I spoke on the then brand new law of digital signatures, and now, which now seems like a quaint and archaic topic, and now we are speaking about AI. And this is actually I think it's the fourth or fifth time I've spoken about AI at RSA. And one thing that I've noticed is the crowds get larger every year. We were just talking about the size of the crowd. I know that's not about me, it's about the topic. So hopefully I will not be disappointing. The other thing about AI, as I said, this is the fourth or fifth time that I've spoken about it here at RSA. You would think that one advantage of speaking about a topic multiple times is you don't have to do much work each time because you just repurpose the same presentation you did the year before. And I will confess that there are some slides in this presentation that I gave last year. But this is not a topic that you can just recycle every year without any change. As we all know, this is a very dynamic area. It reminds me, I was talking to my daughter who is starting as a teacher in the fall, and she was bemoaning the amount of curriculum work she's going to have to put in to prepare her classes. And I said, well, at least once you've got it prepared each year, it'll become easier because you don't have to change very much. I wish that were true with AI. It's not, but it makes it interesting. So obligatory disclaimer. All right. So I'm going to talk a little bit about what artificial intelligence is, how it is used, what are the risks, what are the rules, and then what you should do about them. That's very simply stated, but as you'll see, there is a lot of complexity there, especially because the rules really aren't all that clear. First, what is AI? Some of you may know this, but the term was actually first used in 1956. US computer scientist John McCarthy coined the term. It is a term that is really difficult to nail down, and courts have actually struggled with its meaning. There was a case back in 2020, where someone actually sued because a company was claiming to use AI in its products, and an anonymous blogger posted saying that was BS. They weren't using AI; it was all a sham, and the company filed a subpoena against Google to try to identify the blogger. Because the blogger was anonymous, Google, of course, could identify them if they were subpoenaed. The court refused to enforce the subpoena because it said no matter whether you can find out who the blogger was or not, there's no way you can prove that the statement was false because nobody knows what AI is. And that was in 2020. Now, that's changing a bit now because we have definitions. We've got a little more understanding of what types of things constitute AI. And in fact, just a couple of months ago, the Securities and Exchange Commission settled two enforcement actions against investment advisors who had claimed they were using AI as a tool to provide investment advice to their clients. And the SEC said, no, you're not, and they entered into a settlement requiring them to cease from making those statements. So the term is becoming a little bit more defined. There's an OECD definition, which I paraphrased here on the top of the screen. To define, that looks at AI as an engineered or machine-based system designed to operate with varying levels of autonomy and generate outputs for a set of explicit or implicit objectives. That's incredibly broad, right? Varying degrees of autonomy, explicit or implicit objectives. It kind of encompasses just computers. But you'll see it is an all-encompassing term because people still aren't quite sure what they're trying to address when they regulate it. You see some other definitions that I have there at the bottom of the screen. Of course, we're all familiar with narrow AI and general AI. General AI is what people classically thought of as AI, Lieutenant Commander Data on Star Trek, a fully functional computer that can act as a human. Narrow AI, which is of course what we're seeing more and more in the real world, are AIs designed to accomplish specific tasks. Okay. Now, this is a statement that I quote every year. I really like it. It's from a professor, Ryan Calo, at the University of Washington School of Law. And he says that AI isn't a thing like a train, but rather a set of techniques aimed at approximating some aspect of cognition. Now, why is that important? It's important because if you're thinking about how to regulate AI, it really matters. Are you thinking about AI as a thing, as railroads? We have an agency that regulates railroads. Or are you thinking about it as a set of tools that are designed to do a bunch of different things? In which case, then you might regulate it the same way you regulate everything else in that subject area. So you have housing laws, so you just make sure the housing laws accommodate AI. You've got employment discrimination laws, you make sure your employment discrimination laws accommodate AI. Two very fundamentally different ways of thinking about this. Back when I started giving this presentation 4 or 5 years ago, this was a very open question as to how people would think about it. I happen to agree with Professor Calo. As we'll see, the rest of the world seems perhaps not to agree with Professor Calo. So we'll talk more about that. So what are the risks of AI? Well, first, before you even talk about the risks, it's important to think about what is the standard that you're trying to meet, right? What do we really expect from AI? Do we expect perfection? Do we expect equivalence? They just have to be as good as us? Or do we expect something in between? An improvement over humans, but maybe not perfection. And again, the way I frame the question, I think it's fairly obvious how I'm thinking about it. Perfection is impossible, right? Nothing is perfect, right? But really, I think there's a fundamental feeling that you need to have some improvement if you're going to be comfortable turning something over to AI. Just think about it from in the context of autonomous vehicles, right? We all drive cars, and most of us, frankly, are not great drivers. But we're used to that risk. We take that risk where it's a risk that we're comfortable with, that we're familiar with. If we're going to turn ourselves over to a machine, we want to think that that will be an improvement, that that will be a safer experience than the experience that we can deliver ourselves. And I love this moralmachine.net website. I don't know, is anybody familiar with this website? Raise your hands if you're familiar with it. So more of you need to be familiar with it. It's a great website. It's run by MIT. And what it does is it provides a series of scenarios, autonomous vehicle scenarios, where the autonomous vehicles malfunction, the brakes have given out, and so the vehicle is going to kill someone. It's going to kill pedestrians in the lane in front of you. It might kill pedestrians in the other lane if you swerve to the side. It might kill the passengers in the car. And you have to decide what you want the machine to do. And it gives you a number of different variations. It'll give you different numbers of people who will die in each scenario. It'll give you different types of people: children, elderly, criminals, scientists, doctors, pets, animals are actually in some of the scenarios. It'll tell you that the pedestrians were crossing on a red light illegally. It'll tell you they were crossing in a green light. It'll give you all these scenarios, and you decide what happens. And then it tells you after how you prioritize different things. Do you prioritize children over the elderly? Do you prioritize large people over fit people? Do you prioritize animals over people? Do you prioritize law, like the rule of law, meaning do you make a lot of decisions based on whether the person was crossing legally? All of those things factor into your decision making. And what's fascinating about it, they used to on the website, they don't anymore, give you the breakdown of responses by country, so you could see how people's responses in different countries varied, and they did vary. Some countries valued children more, some countries valued elderly more, some countries valued rule of law more, right? But it really raises an interesting question, because how are we going to make that decision? Do we want to just leave that to some programmer, right? And do we want it to be crowdsourced? Is that really how we want to decide that? So we are the world population, we all vote, and that's how the machine will be programmed? It's a fundamentally difficult question, and it's one that really needs to be thought about as we move into the area of AI regulation. It also implicates something called the AI fallacy. Now, I first came across this term, AI fallacy, in a book called The Future of the Professions by Daniel and Richard Susskind, where they basically told me that I may be obsolete in a few years, that lawyers and other professionals are on the way out because AI is going to take our jobs. Hopefully, I'm old enough that I don't think it'll impact me. But regardless, that was the thesis of the book. But the point about the AI fallacy that they were making was that AI can take an entirely different approach to yield an equally good or even better result. And the example they give is a golf swing. So if you were to be fortunate enough to have a golf lesson with Tiger Woods, he would tell you, I can't even play golf, so I'm not even going to try, how to improve your golf swing. He would tell you how to position your shoulders, how to position your hips, what muscles to use, all of those things to generate the best possible golf swing that you could possibly manage. And AI might approach the issue of how to make that golf ball hit a hole in one in an entirely different way and yet yield the same result, right? Equal to or even better than Tiger Woods. Does the fact that the AI makes that result occur differently than a human matter? That's a question, right? Do we want the AI to mimic our process to reach the result? Or is it okay for the AI to reach that result in some entirely different way that we may not even understand? And the problem with AI regulation today, in many respects, as we'll talk about, is it looks for transparency as to how the AI operates, how the AI reaches that result. When in fact, I'm sure there are people here who program AI, we don't know how the AI reaches that result. But we know what the result is. right? And so that's a really fundamentally difficult question when you're trying to regulate. Do you really focus on the process or only on the outcome? All right, so now let's briefly look at the actual risks that people have seen with AI. So the first, of course, is exposure of confidential information, right? I go to ChatGPT because I've got a difficult legal problem for a client, and so I type in, how does my client address this, particular issue? And the ChatGPT will give me an answer. ChatGPT knows now what I input into the AI and knows that my client has this issue. Depending on I shouldn't use ChatGPT as an example. Depending on the AI model that I use, it may or may not have the rights to take that prompt and use that, or it may spit it out as a result to somebody else. So exposure of confidential information is one key risk associated with AI. Another one, of course, is hallucinations or deliberate misinformation. We all are familiar with the stories about hallucinations. For those who are lawyers in the audience, there have been a couple of notorious incidents where lawyers used ChatGPT to provide case law precedent in their briefs. The only problem was the cases didn't exist. And there was a case in New York where they cited all these cases. The other side couldn't find the cases and said these cases don't exist. So the judge asked the lawyers who wrote the brief to explain themselves on pain of sanctions. And this is the explanation the lawyers gave. Well, I asked ChatGPT if these cases were real, and it assured me that they were. So hallucinations are a problem, right? Another, of course, problem is deliberate disinformation. I don't know how many of you are familiar with Laurie Segal. She's a journalist, and her Instagram is mostly human media. She was at a conference not too long ago where it was the most interesting thing. The people at the conference created a whole false scenario that she was having an affair with Mark Zuckerberg. And they had photos of her with Mark Zuckerberg. They had newspaper articles of her with Mark Zuckerberg. They even had a recorded conversation of her with Mark Zuckerberg, none of which was real. And it was incredibly genuine seeming, right? So disinformation, of course, is a tremendous potential risk associated with AI. Bias is also, of course, a risk. A couple of examples in my experience, well, one in my experience and a couple other ones that are interesting. I had a client that wanted to measure and improve employee productivity. And so what they thought they would do was have an analysis done of employee characteristics and productivity. Characteristics meaning a distance from the office, marital status, those kinds of things, to see if there are any correlations in productivity. Of course, the problem with that is that you might then end up making decisions that are based on protected characteristics. Marital status is one. Race is another, and people, as you know, tend to self-segregate in zip codes. So if you start saying, well, people in this zip code are more productive than people in that zip code, that could lead to bias and discrimination. So they didn't do it, I hasten to say, but it shows us a danger associated with AI. A very simple, well-reported example from back in the early days. A Scandinavian company, I think in Sweden, although I'm not sure about that, was developing self-activated faucets that would activate when you put your hands under the faucet. And they found that the faucets didn't work when you had darker-skinned hands placed under the faucet because the model wasn't trained on different pigments. It was just trained on, I guess, stereotypical Scandinavians. And so it recognized white hands, but it didn't recognize anyone else's. That seems like a minor example. Faucets are not terribly consequential in life, but it shows you how significant those kinds of biases can be. And then my favorite example is Jared. So Jared is a name. And there was a tech company that, and I will say they did not end up using this model for reasons that will become apparent, that wanted to help improve their employee recruiting. And so they said, well, let's look at our workforce. We have employees we really love. Obviously, they're here. They haven't been fired. They've remained at the company. So they're successful employees. What is it about them that makes them successful? And so what they determined was, what the AI model that they used to determine were the two most successful predictors were, number one, college lacrosse athlete, and number two, named Jared. So if you're a college lacrosse athlete named Jared, you had a future at this company. Now, why did the model determine that? Because their employee workforce was disproportionately male, and I guess athletic, right? And so obviously that wasn't a valid result, and they threw out the model. But again, shows you how the inputs that the model uses can lead to bizarre and, in some cases, discriminatory outputs. Infringement is another potential risk. You see here two pictures. One is actually The Starry Night by Vincent van Gogh. The other is a similar picture created with the help of AI. Does that infringe Van Gogh's art? Troubling question, difficult question. Who is the author? Here you've got an image generated by Midjourney on the left after prompts, I think 624 prompts, and then, oh, I didn't mean to do that. And then, go back. And then after he edited it a bit in Photoshop and Gigapixel, the final picture. Is that entitled to protection? So under copyright, I'm not going to go into copyright in detail, but in copyright law, AI cannot be a copyright author. But how much human involvement is necessary isn't all that clear. Similarly, on the patent side, the law requires a human inventor for patent protection. AI cannot be an inventor for patent purposes. But what is an inventor? What level of human involvement is necessary? Again, not fully resolved. So that's another risk associated with using AI. If you're using AI to create inventions, are you going to have ownership rights in those inventions? Are you able to patent those inventions? Is an open question. Now let's look at the inputs briefly. Data is, as it says there, the lifeblood of AI. But how do you get it? And do you have the right to get it? There are all these questions that you have to look at. Number one, do you have data access rights from a technical standpoint to the data that your model is acquiring? Are you scraping the web, and is that legitimate? IP rights. Do you have the intellectual property rights to use the data in the way that you're using it for purposes of the model? Contract restrictions. Do you have contract limitations that limit your ability to use the data? Privacy, right? Does the data include personal data? In that case, privacy laws will apply, as well as privacy notices. And what makes it even more difficult is that data that might be viewed as de-identified, or might have been viewed as de-identified in the past, may not really be viewed that way anymore because it's more easily re-identifiable now with a more sophisticated processing. Ethical considerations. Lawyers don't like to talk about ethics so much, but ethics matter, right? What are our ethical obligations? What are our values as a company? And we'll talk more about that in a bit as well. And then reputational considerations. All of those things go into the inputs that you're acquiring for purposes of the model. I talked about privacy risks already briefly. Here, just sort of elaborating on them a bit more. You see the various issues that come up. You have privacy notice obligations, for example. If data were collected under certain privacy notices that said the data will be used for X, Y, and Z purposes, and X, Y, and Z did not include what you're using it for purposes of the AI, that's a problem. I mentioned already that the de-identification issue. So there are a number of issues on the privacy side that are implicated. There are also security risks associated with AI. We're at the cybersecurity conference, so of course I'm going to mention these, right? There are a number of risks that can be created by your use of an AI model, right? There could be prompt attacks where a threat actor includes malicious information in the model prompts that are designed to influence the outputs, right? They also can leverage the model to attain direct access through a backdoor into your systems. Obfuscation strategies to embed hidden input characteristics behind prompts that seem normal, but that will produce unexpected results. All of these are security risks associated with the use of AI. There's also more traditional security risks, right? People can use AI to infiltrate your system. They can, like the example from Mostly Human Media, they can use voice samples to create what seems to be a real person when it really isn't. It might seem to be your boss, right, telling you to wire money to this new address, right? These are new and very varied types of threats that traditional security measures may not be adequate to meet. So these are all risks that are associated with the use of AI. Okay, so what are the rules? Well, I always, again, for those of you who did hear me last year, you'll know I'm a big Isaac Asimov fan. So last year, I highlighted Foundation and Demerzel as the sort of the AI of the moment. I'm now being a little more classic. Isaac Asimov's iRobot, right? The 3 laws of robotics. A robot may not injure a human being or allow a human to come to harm. A robot must obey the orders given it by a human being, and then a robot must protect its own existence in descending order. The first rule is the most important. Very reassuring, overly simplistic, right? Not really realistic, but nonetheless very cool. Okay. Before I go into what the rules are, it's important to understand why we have rules. Governments are driven by popular concern, by public opinion, and the public is concerned. This is a study that was from 2023 that Monmouth University put out, asking people what they thought about the impact of AI on society. And as you can see, a large number of people are concerned that AI will cause harm. And in fact, when you drill down the numbers, 73% believe that AI will make jobs less available and harm the economy, which is sort of, I was feeling a little bit when I was reading the Susskind book on my future as a lawyer. 56% believe it will harm the overall quality of life. 55% believe it might threaten human existence. So when you have this kind of fear, it's not surprising that you have governments responding to it, whether in a way that makes sense or not. Also interestingly, 55% of respondents favored the concept of a federal AI regulatory agency. That goes back to Professor Kalo. Remember, is AI a train? If it's a train, then you need an AI regulatory agency because you're going to regulate it like you regulate railroads or airlines or anything other sort of substantive subject area, as opposed to a set of techniques where you don't need to do that, where you can just simply make sure that your existing rules cover the use of AI. So what do we have here? We've got a number of evolving laws and regulations. I always like these news cut headline slides because they just show you visually all of the chatter that's around AI regulation. And you see that AI, as probably was evident from when I was walking through the risks, really touches on a number of traditional legal areas. It really doesn't fit neatly into its own category because it touches on consumer protection issues, on data protection issues, on anti-discrimination issues, on criminal issues in the case of, for example, deliberate disinformation, antitrust issues, IP issues. All of these areas are implicated in AI, which makes it uniquely difficult to regulate. The United States, believe it or not, has been a leader in introducing bills on AI. It has not been a leader in passing bills on AI, but it's been a leader in introducing them. When I put together this slide was a few months ago, so the number probably has moved up. There have been 123 bills passed across 31 countries. The United States have proposed over 100 bills in the last 3 years. Now, as I said, introducing bills, not passing bills. So what do we actually have that's been enacted in the United States? So we have state laws, no federal laws. There have been some federal laws that have been enacted to encourage development in AI, to encourage research in AI, but no laws passed regulating AI at the federal level. But at the state level, we do have a number of examples of AI laws. So in the middle column there, I've got biometric laws. Biometrics, I was sort of back and forth on whether to include those or not because they really predate AI and they're not really specific to AI, but they get included. So we have laws about adequate disclosure and opt-out for the use of biometrics, like face identification, retinal identification, things like that. But let's set that aside and look at the two columns on the sides. We have, on the right, laws that require clear and conspicuous disclosure that the consumer is interacting with a bot. That's in California. In New York City, if you're making automated employment decisions, then you have to both disclose that to the job applicant and you have to have your system undergo an annual bias audit to ensure that the system isn't biased. Now, who wants to take a guess on how many bias audits have been conducted since this law took effect? I think it was 2 years ago. 0, right. Why? Well, that might be the real reason. The articulated reason is that they're not using AI tools for automated decision making. They're using them to assist in decision making, but ultimately a human makes the decision. That's the position companies generally taken, so they can avoid that audit requirement. And frankly, I'm not sure how they would do the audit anyway. I don't think they know how they would do the audit. Nonetheless. And then in Utah, there's a law that just took effect requiring disclosure when you're dealing with an individual is dealing with generative AI. And it also clarifies that synthetic data is not personal information, which should have been obvious, but it's good to have clarification. The laws on the left are the ones that I think are the most interesting. They allow a right to opt out of automated decision making. Now, that means not simply that you have a right to know when automated decision making is being made, you have a right to refuse it altogether. When it is something that is going to produce legal or similarly significant effects, but that's most things that we care about: credit, employment, things like that. And you see there a number of states have enacted laws to grant that right. And by the way, Europe also has that right. We'll talk about Europe in a minute. That raises an interesting policy question, right? Does it make sense to allow people to opt out completely from the use of AI in making those decisions? Now, again, it's possible companies will come up with workarounds like we were just discussing in the context of New York. They'll say, well, it's not automated decision making because there's a human at the top. So maybe that's a way to deal with that. but it raises a really fundamental question that goes back to perfection, improvement, and equivalence. If, in fact, the AI system is better, then does it make sense to allow people to opt out from it? I don't know, right? Clearly, people seem to think so. If you could just hold questions, and well, go ahead. What's the question?
Well, it's just a really quick one. How do you also, verify that it wasn't used? Like, how do you have accountability in an opt-out scenario as well? That seems like that would be equally problematic.
Yeah, that's a good question. So I think it depends on how broadly the term automated decision making is construed, which we don't know yet, right? Because if it's simply construed the way I was just discussing it in the context of New York, then that, I'm a human, you're complaining, I'll say, well, no, I made the decision, right? If it's construed more broadly, then that could raise interesting issues. Yeah, but the way people typically find those kinds of things out is through lawsuits. Yeah, so, okay. All right. At the federal level, as I mentioned, there's been no legislation, but there has been a lot of regulatory activity through the executive branch. And actually, it's not simply with this administration. The Trump administration in 2020 issued the OMB, Office of Management and Budget, Principles for the Stewardship of AI. And you can sort of see here on the left very broad principles about promoting trust, risk-based approach, considering the costs and benefits of AI, consider bias and discrimination, providing disclosures, transparency, safety and security, right? Very fundamental principles. And you see those have been carried over into this administration as well with the White House AI Bill of Rights. The FTC had AI guidance that said be transparent, explain your decision to the consumer, ensure your decisions are fair, ensure the models are robust. Now, explain your decision to the consumer is an interesting one, right? Remember we were talking before about Tiger Woods and the golf swing. It's not always possible to explain your decisions to the consumer because you don't always know how the AI model reached the result that it reached. But again, should that matter if the result is better? The FTC says it does, right? That's where we're headed, right, from a regulatory perspective. What's also interesting is that a bunch of federal regulators came out with a joint statement on AI that essentially mirrored the FTC AI guidance. The only reason I have it up here is because of the little box at the top. And the little box at the top was what they introduced the principles with. And they said that AI is, quote, often advertised as providing benefits. So what does that mean? That means they're skeptical, right? The regulators are very skeptical. They're approaching AI with a jaundiced eye, right? They hear the industry saying that AI has benefits, but they're really focused on the risks. And so you have to keep that in mind when you're approaching the use of AI, that you're facing a regulatory audience, both at the state and federal levels, that is skeptical. And so it's incredibly important to be careful, and we're going to talk about how you do that. NIST has an AI risk management framework, which I think is very useful. It talks about how you approach AI governance. You govern, you have to have a culture of governance, a culture of risk management. You map, you measure, right? You look at the risks, assess what they are, analyze them, and track them, and you manage them, right? Very basic concepts, but a nice framework that I recommend that you look at for how you approach AI. Now, the EU just passed the AI Act. It is treating AI like a train, and it's been, it's gotten a lot of good press. People are saying this is great because it provides a harmonized framework across all 20-something EU member countries, and that's true. Unlike the United States, where we got patchwork of state laws, they now have a single standard that everyone within the EU can operate under. But it is treating AI like a thing, right? It doesn't matter what individual market segment you're in, you're regulating AI as a thing. And what do they say? They have 3 different categories of AI. They have prohibited AI, which is what it sounds like. You cannot do this with AI, right? What is that? Use of subliminal techniques to distort behavior in a manner that causes harm. Exploitation of vulnerabilities like age or physical or mental disability in a manner that causes harm. Biometric categorizations of people according to protected attributes. And inferring emotions of individuals in the workplace. I think the first 4, or educational institutions, the first 4 I think are pretty intuitive. I think all of us probably say this is really a bad thing and we shouldn't allow it. I don't know about you, the last one was a little bit, when I first saw it, which is now a couple years ago, surprising, right? Because there could be good uses for that kind of tool. Nonetheless, it's prohibited under the EU AI Act. All the way on the right now, we'll go to the far category, softly regulated. Those are AI models that really don't present significant potential harm, and so they're subject to very light regulation. You have to provide notice, and you basically have to provide notice, right, to the user. The middle category is the most interesting. That's what's called high-risk AI uses, and that's a broad set of categories. It's actually a lot. It covers employment-related, law enforcement-related, financial services-related, all of those kinds of uses that would produce a significant legal or similar effect on the individual are covered in the high-risk category. So what do you have to do if you're a provider of a high-risk system first? So there's a number of requirements you have to meet. You have to have a governance structure. You have to have a risk management system. You have to make sure that you're taking steps to develop robust models and that you've taken the appropriate steps to protect the security of the data. All of those things that we've been, remember that the FTC is talking about are incorporated in more detail in the EU AI Act. Again, transparency is important. Again, think about how you meet that, how you satisfy that criterion when you don't know how the model works. Corrective actions if it doesn't comply with law. Reporting of any serious incident or malfunctioning, right? A whole number of requirements, and the requirements also apply to the users of the system. Some requirements do. You see the list here of the requirements that deployers, which the users of high-risk AI have to meet, which include notifying individuals that they're subject to the use of a system. Also, if you're dealing with employees, you have to consult your worker representatives with respect to the use of the system. Worker representatives are a very strong group in most European countries, and they need to be informed about the system before you put it into service. Okay. These regulations have been approved. They were approved on March 13th. They'll enter into force. Most of the provisions will enter into force 2 years from March. There are some that enter into force more quickly, as you can see. The prohibited practices, 6 months after entering into force. High-risk systems that are in certain subcategories, 36 months. The penalties, 12 months. Penalties can be significant, by the way, up to 7% of your global annual revenue, potentially, depending on the nature of the violation. And then there's something called large-scale IT systems, which are systems that, certain systems that will be designated that are so large, they raise unique issues, will be subject to additional restrictions, but those won't take effect until 2030. Okay, so now what do you do? What do you do with all of this? Okay, so first, awareness. You have to start with awareness. Understand how the technology works, how people are using them, what lawmakers and regulators are saying about the particular models that you're using, if anything, is critical. You also need to have training, and really that training has to encompass employees at all levels of your organization, because it's not just about developing models, it's also about using models, it's about all kinds of potential interactions, and so there has to be some sensitivity. Now the training will vary depending on the job function, but there has to be some awareness across the board. Governance. Governance is critical, and remember how I showed you that screen with the different legal areas that AI implicates, and there are all these different legal areas? It implicates a whole bunch of cross-discipline functions in your organization as well, right? And so the team that you establish for purposes of AI governance really should be a cross-disciplinary team. It can't just simply be, for example, which in the early days we were seeing a lot, your privacy people. Yes, there are significant privacy issues associated with AI, but not just privacy issues, right? So it has to be a cross-disciplinary team. And you have to build in flexibility, because the law is changing here. I told you, we're world champions in introducing bills, but not in passing them. That will change. We will be passing more and more bills, right? So you're going to have to be nimble. You're going to have a structure in place that allows you to respond to changes in events. The process, which I'll walk through a little bit more in a moment, is similar, the way I think about it, conceptually to a DPIA, a data privacy impact assessment process, from a process perspective, but it's much broader than just looking at privacy. So just first, what is AI governance? I think it's important that we always sort of understand what it is we're trying to accomplish, right? A system of rules, practices, processes, and technological tools that are employed to ensure that your use, development, and commercialization of AI aligns with organizational strategies, objectives, and values, fulfills legal requirements, and, I bolded it, meets principles of ethical AI, followed by the organization. This is new fields for people, right? So companies really need to think about, what are our ethical values here? Like, what do we care about? Even if the law isn't yet there, and maybe it never gets there, are we going to have any guardrails for ourselves? And that's going to vary, right, from company to company. As a general rule, I say, looking at it from a very utilitarian perspective, you want to know what your peer companies are doing in your space, because if you're not necessarily, it's not necessarily true that you need to do what they do, but you should know if you are not, right? Because then you're voluntarily sticking your head up, or if you're being more conservative, keeping it down. And that might be fine. That might be right for your company, but you should know it. It should be an intentional choice, not an inadvertent one. So understanding what your peer companies do is important, but then you're going to have your own ethical values and construct, and that should be built into your governance. And there's an AI life cycle, and depending on what type of company you are, whether you're a developer or a user, these life cycle points will have different salience for you. But if you start with development, what are you trying to accomplish? What problem are you designed to solve? Do you need to build it? Can you buy it? Should you license it? Key question, right? Do I have the right team to build and run it? What data can I use to train on it? Remember, IP rights, privacy rights, data access rights, all those things you have to take into account. Then deploy it. When is it ready? Should I beta test it? Yes, you should beta test it. How do I protect it and its outputs IP, right? From an IP perspective, do I care? How do I build trust for it? How much human oversight should I implement? How do I protect it from attack? Output. How do I test the results? How do I know if it's accomplishing what I want it to accomplish? How do I know if it's meeting the Tiger Woods standard for golf swings? Can I use data from my customers to refine it? Do I have the right to do that legally under my privacy notice and so forth? How should I facilitate feedback? Should there be an appeals process? Should I develop reporting mechanisms? And then compliance. Who's responsible? Where do you put this, right? Who's responsible for overseeing it? Organizationally, where do you put this responsibility? Compliance, some companies have compliance departments, some don't. Legal, right? If so, what subject matter specialty in legal? What laws apply to my use of it? Should I follow a particular framework? How do I demonstrate accountability? Should I have my own principles? Those are the kinds of factors to look at. This is just a nice visual way. I don't know, I like visuals, so that's just nice. Okay, risk mitigation strategies. So firstly, you have existing organizational policies and procedures. You have a WISP, an information security program, right? That should be adapted so that it can also cover these new technologies, right? But you also are going to need some new policies. One very fundamental one is an AI responsible use policy. And you need that even if you have no intention, I doubt that's true of anybody in this room, but even if you had no intention of using AI, you need to have an AI responsible use policy because I'll bet your employees are using AI, whether you know it or not, right? And so understanding what restrictions you want to put into place is important. Updating existing policies to address AI risks. So I mentioned security already. Restrictions on the use of confidential business information with generative AI, right? Telling people what they can and cannot do when they're interacting with generative AI. Privacy impact assessments for AI, if you're going to be using AI. Approval workflows. For example, if you're going to use AI, let's say you're a public company and you're going to use AI to generate investor communications, right? You need to have some approval workflow in place. You can't just have an AI-generated investor communication go out without human oversight because you might end up violating SEC regulations. If the AI says something it shouldn't, either because it's not true or because it's not public, right? And so you need to have some kind of approval workflow in place. That's just one example of something that we deal with. Supplementation of vendor risk management. Are your vendors using AI? If so, what kinds of rules do you want to put into place in dealing with those? Just as an example, in the legal industry, for our law firm, we now add to our engagement letter language about our use of AI so that a client is aware, and if a client has a problem with it, they can tell us, no, they don't want us to use AI tools. And then again, what are our corporate values? Ownership strategy. So this goes back to what I was saying before. Build or buy, right? How are you going to be using the AI outputs? Does it matter if you have ownership rights in them? Sometimes it does, sometimes it doesn't. I had a video game client, and they wanted to use AI to help write code for their video games. The problem was that the particular model they were using was such that they really couldn't necessarily claim ownership to the code that was being generated. There was also, frankly, a risk of infringement because of the way the AI obtained the data that it utilized. At least it's a non-zero risk of infringement. And so what they ended up deciding was, well, they weren't going to use the AI for their core game, for things that were important, their main characters, their main themes, because they couldn't risk not owning that or having it be deemed infringing. But for background, for like generic characters and bushes and shrubbery and things like that, doesn't really matter. If it turned out that it was infringing, they could just take it down. They didn't need to own it. They didn't care if somebody copied it. And it was a lot cheaper and quicker. So that was the judgment they made. It was a risk-based decision, right? So you have to think about, okay, do I care? How am I going to be using this? Is it important that I own it, or is it important that I be protected against claims of infringement? And if it is important, for example, to own it, then you need to incorporate human authorship, because remember what I showed before, under copyright law, you need to have a human author for it to be copyrightable. Under patent law, you need a human inventor. So if it's important that you own it, you need to figure out a way that we're going to make sure we have sufficient human ownership that we can claim those IP rights in that data. Make sure you understand, as part of the diligence, how the tool works to the extent that you can, how you intend to use it. As I mentioned before, always pilot or beta test before you roll it out. And then periodically test the models to confirm that they're operating the way that they should. Contracting. So this is really important as well. When you are licensing customer data, you have to understand two things. Firstly, when you're providing your data to a vendor, you have to understand what rights they're claiming to use the data, right? So general commercial consumer contracts, like the generic models that are free, right, allow the AI model to use your data for all kinds of internal purposes, right? They're not really appropriate for a company that's looking to use a model for its own internal corporate sensitive information. So you need to negotiate that, and they have now bespoke contracts where you actually, where they tell you they won't use the data in that way. But making sure you understand what the contract says about what they can use your data what they can use your data for is imperative. And the same is true for you. If you are going to be using your customers' data to improve your AI models functioning, you need to make sure you have the rights in your contracts with your customers that allow you to do that. And many of your contracts will, of course, predate your use of AI. And so they won't have contemplated this. And so what you then need to do is sort of do a risk assessment with a lawyer, right? Do we think the language is broad enough to cover this use, or do we need to go back and amend the contract? And of course, the risk is that if you go back and amend the contract, the client may say, no, I'm not letting you do that. Why would I let you do that? And if you don't go back and amend the contract, you run the risk that you're actually exceeding your rights under the contract. And so it's not a straightforward question, because this is something that wasn't contemplated when the contracts were written. Understanding that is important. Also, when you're using, I'm just picking some of the things on the slide, when you're licensing a tool from an AI provider, right, allocation of liability for damages in the event of infringement. Let's say, go back to my example of the video game company that's using the AI software tool to write software for its background characters. If it turns out that those characters infringe, who's liable under the contract with the AI tool provider? Again, if you're using the sort of the standard consumer contract, the generally available one, they have no liability, right? But if you're in a commercial relationship with the AI tool provider, you can negotiate that. And there's no market yet for this. There's starting to emerge a little bit, but there really isn't a market yet, and so it really is a negotiation. Similar question on indemnification. Who is required to indemnify whom if there is a lawsuit as a result of infringement or privacy violation or anything of that nature? And as I mentioned already, when you're thinking about what makes the sense in any particular context, looking at, is this a core issue? Is this a peripheral issue for my company? How do I intend to use this? All of those questions will go into what model works best for you. Is it, what kind of contract you need? And it's not going to be the same answer for everything you do, which is why you need a governance structure in place. So for this project, we can use an off-the-shelf contract because it's not sensitive. For this one, this is our core IP. We want to make sure we really understand what's going on, and we need to negotiate specifically with the vendor, right? So 2 different AI uses will necessitate 2 different approaches. And then, of course, security. It's incredibly important to make sure, I don't need to tell anybody in this audience this, right, that when you're integrating a new tool, you need to understand what the security risks are. And because of the nature of AI, it creates its own new security risks. And so making sure your own CISO and security team understands what those risks are is important. And so that may require new training, may require new personnel, new thinking, because these are new issues. Although maybe they will get all they need at the conference. Okay, and I think that's it. I'm ready to take questions if anybody has them. Yeah. Yeah.
So, it's kind of like a long question, but... Are you able to go up to the mic? Sorry. If you guys have any questions or if you want to talk to Ben, we've got 2 microphones up here at the front, and we've got about 10, 15 minutes,
Okay.
I think, for questions.
I think 5 minutes.
Okay, first question. So, yes, we've got about 15 minutes until
15?
the session
Okay.
ends.
Okay, go ahead.
Okay, real quick. My name is Jay Bryant. I am a cyber risk professional at a financial institution. My question is, well, so it's a statement and a question. At present, the authority on AI seem to be legal reps, government, and academia. Okay? So what I've seen as a mid-level cybersecurity professional is that we're not really being called upon. So I work at a large financial institution, and I'm not seeing, and even the requisitions that I see out there for AI professionals, it's really centered on data scientists and software engineers, not so much risk professionals. So while cyber is super important for AI development and widespread application, where are you seeing and hearing the cyber industry's voice on this matter? Is it like just CISOs at conferences? Where is the cyber's voice coming from?
So it's a great question. I'm not seeing it at all on the regulatory front, honestly. The regulatory front's been really focused on the kinds of discrimination and equity issues that I talked about earlier. The security piece is really driven entirely internally by CISOs and by security functions at organizations. Yeah. So, which is problematic. Yeah. Yes.
Hi, Benham. Just thinking back to the concept you mentioned.
I'm sorry.
Oh, I don't.
No, you're on. It's on. I just couldn't hear. I'm sorry.
I don't think it's on. Okay. You mentioned the concept of opting out of AI decision-making biases. Do you think the concept of AI-based and AI-assisted decision-making is quantifiable? And is that an aspect that should perhaps be regulated?
Do I think it's quantifiable?
Quantifiable.
What do you mean?
So is there criteria for what constitutes AI-assisted versus AI-focused or AI-centered decision-making? And is that something that should be a focus of regulation?
Yeah, so I'll answer the question from a U.S. perspective because candidly I'm not sure whether under EU law there is more definition. But in the United States, no, there isn't really any clear line. And that's why in the context of the New York City law that I mentioned, every employer is taking the position that it's AI assisted and not automated decision making. And it's probably because in some cases, yeah, a person looks at the decision the AI recommends and just checks off on it, right? So there isn't. Should there be? I don't know, because I struggle with the premise. On the one hand, I certainly would not want necessarily to be subject to an automated decision that I never can talk to a person about, but I recognize the irrationality of that feeling. And that feeling might not be irrational today, because today AI still is full of issues and still evolving, but it might be irrational in a year or two, right? And so I generally don't like to enshrine into law things that will change rapidly, which is why I was making fun of the United States for not passing laws, but I'm not sure that's a terrible thing. Sometimes you can put something in the law and then you end up you're stuck with it, right, for a long period of time when it doesn't make sense any longer. So today, no, there are not clear guidelines, and I don't know that that's bad.
I guess I was thinking around the fact of whether it could be an easy way out for companies to say that the involvement of AI in that decision was minimal, and therefore I have no basis to participate in that.
Yes, if it's abused, it certainly could.
Is that a danger?
Yeah, it certainly could. It is a danger. Yeah, I agree.
Okay.
Yeah.
Hello, thank you for your presentation.
Sure.
I'm a cybersecurity auditor with an OIG. We look at healthcare agencies, hospitals, and stuff like that. And I think right now we're curious as to how we can even form an audit on AI. I think you touched on it earlier. What time frame do you think there is for the U.S. to actually develop bills that can be used as criteria for an audit to ensure that it's not being abused?
So I don't think you need to have a law to do that. I think that right now, for example, the NIST risk management framework provides a nice standard to help develop that audit structure. And you have the agency principles that I mentioned before that the FTC has put out, and the joint interagency guidance that talk about things like notice and bias and disclosure. And most of those, I think, are fairly simple conceptually, right? Transparency is difficult, I think, and maybe there needs to be some further regulatory guidance, but candidly, I'd be worried that the regulatory guidance might be problematic because, as I said before, it's not always easy or even possible to explain how the AI reaches its result. But I do think you have there are enough guidelines in place now that you can do that.
Okay. And lastly, are you familiar with the GAO AI framework?
The NIST AI firm.
I was curious if you're familiar with the GAO.
Oh, the GAO.
Yeah.
So the GAO, yes, the GAO framework I think followed OMB, and I think it's substantively the same. I'm pretty sure.
Thank you.
Sure. Yeah.
Yeah, I wanted to touch base on that New York law, the New York City law.
Yes.
It says if you're using it in automated decision-making related to employment, you need a bias audit. One thing about that law that I've noticed is that there is no standard. You know, if you have an audit that determines your system is 60% biased, whatever that means, that's fine. You know, it doesn't say that your system has to be unbiased to a certain degree. It just says you have to have an audit. So the audit could say literally anything. What do you think the point of that law was if it really has no teeth? It's not pointing towards anything in particular that a company must actually do.
So I'm not an employment lawyer, but I will tell you what I think. I think that the standard you have to meet is the same standard you have to meet without the use of AI, right? In other words, if I don't use AI and I'm biased in some of my decisions, 60% of my decisions are biased, I'm violating the law because the law requires me to be unbiased in my employment decisions. So I think in this context, if your AI system showed that you were 60% biased, whatever that means in the context of the thing, that's subjecting me to enforcement action and to lawsuits because I'm not allowed to be biased at all.
Well, perfection isn't a standard. So.
Well, but when it comes to employment discrimination, forget about AI. In general, it is right. If I am biased in my decision to hire you, I'm liable.
You're 100% biased.
Right. Yes. Right. Yeah.
Hey, how you doing?
Good.
And I would just want to say thanks for the presentation. I enjoyed it a lot.
Pleasure.
One big question I do have, like, you're going over the governance, and also one thing I did notice that you have that a lot of people don't present when they talk about AI is more the risk and more of a nice risk mitigation plan as well. Normally, everybody who's trying to introduce that into an organization, they only want to talk about the good stuff and the benefits in order to try to sell you on it and try to get it into the infrastructure. But my thing that I have a question about as far as like what you're seeing from more of a communication standpoint. So is there any form of, a consistent, singular form of communication plan when actually introducing AI into your organization? From a messaging standpoint, I've been told that generally what you're going to do is try to indicate just the purpose, the actual data, and how you actually want to utilize it within the organization. But are you seeing something from more of a national standard type standpoint in communication and the messaging? That way we're seeming like we're all on the same page.
So if you by national standard you mean some kind of regulatory or governmental guidance, no. But what our clients do, what we advise them to do, is to articulate clearly what the intended uses are, what the permissible uses are of the AI,
Sure.
right? And who is entitled to use it, and what are the conditions and limitations under which they can use it. So, for example, I mentioned before the investor communications, right, purpose. So there, if you're going to allow AI to develop, the use of AI to develop the use of external-facing communications, you have to say, okay, it's okay for these kinds of communications, but not these kinds of communications, and it needs approval from X, Y, and Z person before it can be released, or it doesn't, right? You have to lay that out so it's very clear what the uses are, and that's for whatever the use is. Back to the video game example, right? You can use the code for these ancillary things, for shrubs and hedges. You can't use it for primary game mechanics. And so, to me, the most important thing is being very clear in your internal communication to your workforce, who's entitled to use it and what they can use it for.
Okay, because I work more in like the health side,
Yeah.
the website, so we're pretty much dealing with how we actually utilize it in a way that it's not pretty much causing any issue with any form of HIPAA laws or
Right.
any form of stuff
Right.
with CMS. And so
So
the
there-
messaging is crucial as far as like how we get it across with introducing it into our environment. So that's why I was trying to
Yeah.
get some pointers on what
So,
you guys are
so
doing.
there, I'd be really careful about HIPAA and about what data you allow to be input into the AI model, right? Depending on the model and what you're using it for, whether or not PHI can be input into the model will be something very important to delineate your policy and your internal communication. And then again, what you can use, what the tool's intended to be used for. That would be sort of a key issue to address.
Okay. All right. Appreciate it. Thank you.
Sure. Yeah.
Thanks for the session. I would like to ask about the metrics to make sure that we have the right AI setup. At the same time, jumpstart for the policies that we can reference to. And that's going to be very helpful. Thank you.
So the metrics.
Yeah.
So I don't think that there's one set of metrics. I think it depends on what you're planning to use it for.
So I wanted to make sure that the AI is secure.
Oh, it's
For example-
secure.
Yes.
Okay. So that's a CISO question, right? I mean, I think that that's where you need to talk to your security team, make sure they understand the tool. Are you hosting it? Are you accessing it externally? How is it being used? What information are you providing to it? What access is it going to have to your systems? There's no legal test for that. That's like anything else. That's your WISP, right? It needs to be incorporated into that WISP so that you're making sure that it's been adequately addressed.
So there are cloud-based AI and there are
Correct.
on-prem, and there are enterprise-specific ones that are on cloud.
Yes.
And we wanted to combine the things with the legal stuff. You mentioned your JV, your customer data. So it would be great if there is a framework, like for example, NIST have great framework for CSF,
Yeah.
for 853 for the common control. But we are missing this guide in AI. There is a taxonomy from NIST, but it's just a dictionary.
Yeah, right. So, I mean, you're raising a good question. I don't know, because this really is a technical security question, whether or not it would make sense for NIST to have something more specific on that, or whether there isn't really that much difference conceptually between a cloud-based AI system and a cloud-based, any other system versus on-prem. I mean, AI does create new vulnerabilities, but I don't know if they're different in kind such that you need to have more specific guidance from NIST. I don't know. I really don't know. I think that really is a CISO type technical security question.
Thank you so much.
Sure.
Appreciate it.
And by the way, the NIST AI Safety Institute Consortium, which came out of the executive order, I think it will be addressing things like that.
Oh, that's great. Thank you.
So stay tuned.
Thank you.
Yeah, it's just starting. Yeah.
Hi again. So I wanted to know, what sort of research team did your firm employ to investigate the ownership rights for that software that the video game client wanted to use? Like, if it wasn't the attorneys who were looking at the code to determine, what sort of technologists did you?
So it wasn't a technology question. It was a legal question. We looked at the agreement that they were entering into to use the tool, and the agreement gave them no protections in the event of infringement, right? It said basically, we're not responsible if the code the outputs that you generate using our model are infringing. And we knew that it was a model that was developed using data that they acquired sort of off the internet. And so we said to the client, there's no legal protection here, that any code that you create is going to be non-infringing and that you'll own it. So that was purely a legal question. Factually, whether it's infringing, we don't know. Nobody sued them yet so far, right? But the issue is that they're at risk. So the question was, who are they leaning on to be the authority to say the code isn't infringing? They're not. In other words, they're taking a risk. But they've made a business decision that it's okay to risk that this code might be found to be infringing in the future because it's so peripheral to our operation that if that happens and we get a cease and desist, for example, we'll just take it out of the game. And they might have some damages, but they decided that the savings they're realizing are so great because instead of having 10 programmers spending months, they have like one programmer, one person, prompt engineer, and they've generated the code. Sure.
Thank you so much, Ben. We're going to have to wrap things up.
Thank you.